Good evening, everyone. Thank you very much for coming this evening and attending this seminar on the immediate legal implications of Brexit in the Constitution. We're delighted to see such a fantastic turnout. I just want to say that this is not operating under Chatham House rules. Everyone's free to tweet and blog and do as much of it as they want to, and the hashtag is #Brexit law. And I'll hand over straight away to Clive Coleman, who we're very, very honoured to have today chairing our event. Thank you very much.
Thank you, and a very warm welcome. Let me echo that, ladies and gentlemen. Thank you all for coming along this evening to Brexit and the UK Constitution. Well, ladies and gentlemen, it has actually happened. For those of you who are secretly still harbouring a desire that you might perhaps wake up Bobby Ewing-like in the shower, and the tumultuous events of the last 6 weeks or so will all seem like a dream. That isn't going to happen. The UK did indeed vote for Brexit on June the 23rd, and what drama there was in the lead up to the vote, and indeed what drama there was that followed. Boris led the victorious campaign. He became the front runner for the Tory leadership. He soared high, only to be stood on by his campaign colleague Michael. Boris stood down from the leadership contest with Michael. Michael stood up, but was soon eliminated. Andrea then stood up, but then stood down. Theresa stood tall and triumphed, and then stood on Michael and George, but not on Boris, who stood up again. It was also terribly predictable, wasn't it, for us in news, just what we were expecting. But the referendum vote has thrown up a huge number of constitutional issues, many of which we hope to address this evening. Let me just menu a few of them before we hear from our distinguished panel. Was the referendum legally binding, or was it simply a political mandate? Article 50 of the Lisbon Treaty, with which we're all becoming so familiar, the mechanism for leaving the EU. Who triggers it and when? Can it be done by the Prime Minister alone, exercising her executive prerogative rights? Or does there need to be an act of Parliament giving her the authority to do so? Legal challenges are stacking up at the Royal Courts of Justice. Can Article 50, once started, be paused or indeed scrapped? Or is the democratic juggernaut that was released by the referendum vote now hurtling inexorably, or perhaps that should be chuntering inexorably towards the exit doors of the EU? And what will be included in our divorce settlement? Will there have to be a separate trade deal that will take far longer than the 2 years allowed under Article 50? And if so, what will that look like? Will it look like the Swiss model? Will it look like the Canadian model, the WTO model? Will we remain, can we remain in a single market and at the same time limit the free movement of people? And what of the EU law that is now so much part of our own law? The fact that over the last 40 years our law has been growing up alongside imbibing EU law, and that law now courses through the veins of so many areas of our own domestic law. How are we going to go through the process of analysing what we want, what we don't want, and getting rid of those parts that we don't want? And how will our courts deal with EU law post-Brexit? Are we in and bound by it all until we're actually out? And indeed, perhaps most pressing of all for many people, what are the implications for the UK and its devolved parliaments? Now, to address these questions, we have a stellar panel assembled this evening. Sitting on my left, you will recognise, of course, former Lord Chancellor, Lord Falconer, who it is fair to say has pretty strong views on who is and isn't suitably qualified for the role of Lord Chancellor. And I know that because he was actually good enough this morning to get up very early in the morning to do some filming for a television package that ran on the 1 o'clock news that I did today. But as you will know, he was the first Secretary of State for Constitutional Affairs in 2003 and became the first Secretary of State for Justice in 2007. To my right is Dominic Grieve, who also needs very little introduction, a very distinguished barrister, parliamentarian, and of course a former Attorney General. let me go to my extreme left, Richard Gordon. Richard is, as you know, leading QC in administrative, public law, constitutional law, EU and human rights law. Few people, I think, can claim to have sat down and written a written constitution for the UK, but Richard is one of that very select group. To my far right is Professor Joe Shaw. Joe holds the Salveson Chair of European Institutions and is the director of the Institute for Advanced Studies in Humanities at the University of Edinburgh. Joe's teaching and research focuses on the field of the EU Constitution and institutions, particularly in socio-legal and interdisciplinary perspectives. And then just two along to my left is Professor Derek Wyatt. Professor Wyatt is visiting Professor of Law at the University of Oxford, specialising in acting as counsel in international litigation before the European Court of Justice and the EU General Court in Luxembourg, and in giving legal advice to businesses and governments. He's given evidence on EU law issues to the German Parliament, the British Parliament, and to the Bank of England Financial Markets Law Committee. So that is our panel. Just let me lay down the format for the evening. What I'm going to do is I'm going to ask each of our panel to speak for 5 minutes on, frankly, any aspect of the constitutional issues that have arisen since Brexit that takes their fancy. I'm not sure how much briefing they've had in advance. I hope there isn't too much repetition. I'm sure there won't be. But once they've done that, and I'll fairly strictly enforce that 5-minute rule so that we have plenty of time for questions from you. When we do get to questions, please ensure, if you would, that your questions stay on the right side of that border between question and extremely long statement, so that we get the maximum contribution from our panel. But please also, when you ask a question, do tell us who you are and where you're from. Okay, so without further ado, let's start. And as I said, there is no particular pecking order. We've just had a bit of a discussion, and this is the order that I've come up with. So I'd like to start, if I could, by asking Lord Falconer to kick off. And let me give you the microphone.
Clive, thank you very, very much indeed. We are completely in uncharted waters. I wonder if when we were negotiating the Treaty of Versailles, we had a similar problem, or probably the Treaty of Versailles gave rise to less problems than the problems we've now got. I think there are 4 facts that are indisputable. First of all, the result of the referendum is advisory only. Secondly, we remain in the European Union until we do something. Thirdly, it's up to us, when we serve the Article 50 notice, that starts the clock ticking. If nothing else happens, after 2 years from the date of the service of the Article 50 notice, we are out of the European Union. But in the meantime, we remain in the European Union on all the terms that currently exist. Those, it seems to me, are the only givens in the position. Taking each one of them in turn, first of all, it's only an advisory referendum. Yes, it's only an advisory referendum, unlike, for example, the referendum after the Scottish Parliament was set up, after the devolution bill, which, once there was a yes vote, automatically triggered some provisions. But I don't think there is any politician, well, there are some, but there aren't many politicians in the country who say that it is anything other than an effective instruction to the politicians to now start negotiating our way out of the European Union. I don't think that that necessarily leads to the conclusion that we do ultimately leave the European Union, because I think the effect of what's happened is that we have to try to do our best to get out of the European Union, because that's what the public wants to happen. I know it's 52-48, but we live in a democracy, and ultimately the view of the majority on an issue like this not only normally prevails, but that was the whole purpose constitutionally of the referendum. A point will be reached where it becomes clear what broadly the terms are on which we will be leaving the European Union. It will then, I think, be for the government to decide whether or not it then simply goes ahead with what has been agreed, or whether it requires a general election, or even another referendum, to get approval of what has happened. But the current position has to be that the government does its level best to get out on the best possible terms. Now, there's an intermediate step constitutionally, I think, which is, does the government need to do something to have a mandate to determine what its negotiating position is? The debate about whether or not we left the European Union hinged around three particular issues. One, should we stay in the single market or have some other arrangement? Two, what should we do about immigration? And three, what should we do about budget contributions to the European Union? If we can get to a position where we have absolute control over immigration, secondly, we can get into the single market on the identical terms to the present, and three, we have to make no contribution to the EU budget. That excellent arrangement would not, in my view, require either a further general election, second referendum, or anything else. The further away we get from those three paradigms, the more there will need to be some democratic endorsement, not just of our negotiating position, but also whatever deal is reached at the end of the day. And I think this will take a lot of time. We currently have what's called a Brexit department, presided over by Mr. David Davis. That is a group of Mr. David Davis and 20 people in a room in the Cabinet Office, all, I would imagine, from my experience of setting up new departments, focused on fighting for bigger and bigger rooms for each other, rather than identifying what our position should be. It will take us a long, long time to get a properly formulated negotiating position, and what's more, in order to formulate that negotiating position, it will be necessary to go round the capitals of Europe and find out what is possible before we even think about serving our Article 50 notice. Once a position is formulated, then it is for the Prime Minister to decide whether or not she needs to go to the country. But ultimately, there needs to be some sense that what she is doing has the approval of the country, both in the negotiating position that she's taking up, and then when she gets a final position, whether or not the country approves it. Because otherwise, the whole nature of where we end up, both in relation to our relations with the European Union and in relation to our relations with other countries, not just in relation to trade, but in relation to much broader issues as well, will be determined without any mandate whatsoever. And although there is no constitutional requirement or no legal requirement for Mrs. May to go to the country before 5 years are up, if she ends up in a position where she identifies a negotiating mandate internally, negotiates, does the deal, and never asks the people at any stage for the approval from it, unless it is that paradigm deal, these huge decisions for the country will have been taken without any reference to the public whatsoever. Now, I said I've got more than 5 minutes.
No, pretty good. Just a minute or so.
Okay, I'm sorry about that.
I was just thinking there, actually, that if David Davis and his team of 20 are really tough in those negotiations for those bigger rooms and arrive at a situation where they get huge rooms, that might just toughen them up for the Brexit negotiations to come. So it may be a very good thing. Let's move on to Dominic Grieve, who I know is quite keen to talk about the politics.
Thank you very much, and for inviting me here this evening. I suppose, having spent all my life in a state with an evolutionary constitution, it is quite a remarkable moment to wake up and realize that we are experiencing the biggest revolution since the Civil War of the 1640s in constitutional terms. Certainly, I think, since 1688, but I think arguably since the Civil War of the mid-17th century. The world has effectively been turned upside down by a vote which delivered a majority of 1,200,000 people wanting the government to implement their view that we should leave the existing constitutional framework that is currently surrounding our country. And perhaps not surprisingly, the first thing that happened is that the entire edifice of government ground to a halt, because those who had advocated this course of action hadn't the slightest idea of what they were supposed to do next. Indeed, not only didn't they have the slightest idea, but they weren't even able to put together an idea in the succeeding 2 weeks sufficient to persuade a majority of MPs in the Conservative Party that they might be worth following. That then leaves the new Prime Minister with an enormous challenge. I can't think of a Prime Minister in peacetime who's been dealt a worse hand. How is she going to lead the country out of the EU? And I agree entirely with what Charlie Falconer said about respecting the public will. I'll come back to that in a moment. And take them to a destination which is a credible one and maintains the national economy and their quality of life. And, in the interim, keep the party she is leading together when a majority of the members of that party, undoubtedly, certainly up to the day of the referendum, thought that we should remain. Although doubtless it's true that some of those may have done it out of loyalty to the previous Prime Minister and may not have very strong views on the subject one way or another. How is that to be done against a background where many members of Parliament in both political parties are being bombarded on a daily basis with messages from constituents telling them that unless they sign up in blood immediately to an undertaking that under no circumstances will anything be done which prevents removal from the EU, they will be damned forevermore or have a brick through their window. This may be a tiny minority, but it's certainly the minority which is vocal at present, even in leafy South Buckinghamshire. And of course, if you're in a northern town as a Labour MP, then the minority may be even more vocal in that context. And how are we to heal what is, without doubt, the manifestation of a very severe breakdown in trust between the electorate and the governing institutions of this country, which I think has been a long time coming because I've talked about it in the past, but of which this is perhaps the ultimate manifestation. But it's been around for a considerable period of time. Indeed, the Scottish referendum, I think, was in many ways the reverse of the same medal in terms of some of the public attitudes which that referendum revealed, and the public hostility to the political institutions which govern their lives. How are we going to put all that back together again? It's an immense challenge, and I don't think I necessarily have any of the answers. My impression of what the Prime Minister is trying to do is perhaps the only thing she can do. First of all, to demonstrate leadership and assert her authority, which she's done pretty effectively, leaving the field strewn with some dismembered corpses, mostly meeting with public approval in their dismemberment, and has then proceeded to put together a cabinet and to give them very firm instructions that Brexit means Brexit, that she and the Brexiteers that she's appointed will take the country forward in the negotiations, and that she is going to do everything she can to maintain public confidence, that the outcome will be one which the public will find satisfactory and will deliver those wonderful tests, which I agree entirely with Charlie, which is, of course, the thing around which 99.999% of the country would happily coalesce, be they Labour or Conservative. Or UKIP, for that matter. Even UKIP. How we get from A to B, however, is another matter. Just trying to look in the shortest term, the first issue is obviously Article 50. I agree entirely with Charlie that the referendum is advisory, but the fact it's advisory does not mean that it must not be followed. It would be an act of political insanity, in my view, and also of contempt for the electorate, who are already contemptuous enough as it is, if we were to turn around and say that we were not going to do what we had asked people whether we should do or not. How we go about implementing Article 50, I think, is much more interesting. My personal view is that there has to be a vote in Parliament before Article 50 is invoked. I don't want to get drawn into the legal niceties of that at the moment. I don't really think it matters whether it's convention or law. Even if it's convention, there must be a vote. And I think, in my view, a vote in both houses of Parliament, not just the Commons. But there is an argument that, in fact, the royal prerogative has been eroded in this area. It's not a question to which I have any answer. Others may have their own conclusions, but there is a credible argument to be made on it, even though the government's own legal advice has clearly been that it's not, and it's a prerogative issue. As for how we then deal with the implementation of Article 50 once it's invoked, one only has to look at the negotiations currently beginning to take shape in Europe to see that the smooth running of Article 50 as envisaged by the drafters is unlikely to happen in practice. It is going to be enmeshed in politics. But clearly the United Kingdom, once Article 50 is invoked, is in legal terms appears to be at a disadvantage, because unless we can conclude a sensible agreement within 2 years, we can leave in chaotic conditions. Nobody wants that, however, so it's difficult to envisage credibly that our European partners would wish to see that happen. There's a big issue over the Union of the United Kingdom, but I shall defer to Professor Shaw on that. I'd only say this, that it's as much a political as a legal issue. I don't actually think the Sewell Convention gives the Scottish Parliament a right of veto over the United Kingdom Parliament and government's decisions in this area, but it's a matter which cannot be excluded from the government's consideration, and it's abundantly clear that the Prime Minister understands that very well indeed. As for all the other issues that cascade down, I'm going to leave those to the discussion because I've exhausted my 5 minutes. But it just highlights the fact that we are just starting to dig a very, very big mine and have only done the first few shovelfuls. We hope that we will find the golden nugget at the end, but it's going to be a long way before we get to it.
Right, well, thank you, Dominic, for terrifying everyone, I think, in the room, certainly me. Okay, could I ask Professor Derek Wyatt? You want to go? Yeah.
I shall just say a few words about how to ensure accountability and transparency when the UK negotiates a new trade agreement with the EU. The UK will shortly negotiate a treaty on its future relations with the EU. It will be an important treaty, and perhaps a uniquely important treaty. The UK has not negotiated a trade agreement for some time. That is because the EU negotiates trade agreements for its members. It's been said that too much of the EU negotiating process has taken place behind closed doors, and that has led to criticism not only of process, but also of the content of the agreements. There has been criticism of the draft TTIP agreement between the EU and the United States, and increasing criticism of the agreement between the EU and Canada. That said, there has been much more transparency in EU treaty making in recent years. This has included publication of negotiating mandates, liaison between the Commission and the European Parliament, and consultation with civil society. The forthcoming UK negotiations with the EU and with other potential trading partners should meet high standards of parliamentary accountability, transparency, and public involvement. This will involve constitutional evolution for the UK rather than simply picking up the threads. The referendum has narrowed the options of UK negotiators. In any future trade agreement, the UK must control immigration. The UK must not be bound to apply EU law, and the UK must not be bound by judgments of the European Court of Justice. Yet UK negotiators will be expected by Parliament and public to achieve a comprehensive trade agreement with the EU, covering trade in all or most goods and in a wide range of services. Jobs will obviously be at stake. There will be a high degree of public interest in the process. Parliamentary accountability can be ensured by enhanced parliamentary oversight of negotiations. The House of Lords EU Select Committee has called for this. Vehicles for this could be existing EU committees in the House of Commons and the House of Lords. Ponsonby, even with current statutory muscle, would be woefully lacking. If the future agreement is to have lasting credibility, it should be backed as far as possible by a cross-party consensus. Parliamentary oversight of the negotiations could contribute to this. Seeking consensus on negotiating objectives will also involve consultation with devolved administrations, and with Gibraltar. This process seems to have started. A broad consensus, in general terms, should not be difficult. The government might say it seeks future trading opportunities which replicate as closely as possible the single market opportunities enjoyed in the past. But there might be important exceptions to this. One possible exception was raised recently by the Prime Minister. She referred to the power of government to block unwelcome foreign takeover bids. This is not currently possible vis-à-vis EU companies, but that option could be reserved in any future agreement with the EU. While a future trade agreement will seek to replicate single market opportunities, I am not arguing that it should replicate the single market legal model. Perhaps more of that later. Public involvement in formulating the UK negotiating mandate would provide crucial technical support for UK negotiators. UK businesses which trade with Europe can identify features of the single market which have delivered actual benefits. Businesses may report that other features have failed to deliver in practice what they promise in theory. UK negotiating priorities must focus on securing real-world commercial opportunities. While businesses might be in the lead in pointing UK negotiators in the right direction, they should have no monopoly on the government's ear. Trade unions, NGOs representing consumer and environmental interests, and think tanks and pressure groups all have a place in defining the new relationship with Europe and the world that the UK will be seeking to bring into being. Constitutional principles of accountability, open government, and transparency pull in the same direction as efforts to empower UK negotiators. What are needed are some defined mechanisms which will ensure parliamentary oversight of negotiations and also give a voice to businesses and civil society during the negotiating process. It might be that the enhanced parliamentary oversight to which I have referred would provide a forum for input from business and civil society as regards negotiating objectives and the progress of negotiations. Thank you.
Thank you. Thank you very much. There's so much to pick up in all of these contributions, so please do make mental or make actual real notes, and we'll come to them in due course. But can I ask now Professor Joe Shaw?
Thank you very much. Thank you for the opportunity to speak at this event. But I'm afraid that please don't look at me to come up with recipes for fixing the blowing apart of the union state that I only came properly to appreciate once I moved up to Scotland about 11 and a half years ago. I think it is very significant that when Theresa May came to meet Nicola Sturgeon last Friday in Edinburgh, that she then talked about the importance of a UK-wide approach and objectives. She also talked about associating the Scottish government fully with the process. And I think to a certain extent, we can therefore hope that there isn't going to be an antithetical or an oppositional approach necessarily here, in the sense that the notion that a scenario that works well for, say, Scotland and Northern Ireland and indeed Gibraltar is necessarily one which is antithetical to the best interests of the UK as a whole. It's worth remembering, and I'm sure this is going to be regularly remembered in the corridors of the Scottish government, that the question on which Scotland voted 62% to 38% in favour of the answer Remain, the question was whether the UK should remain within the European Union. So it's not implausible to imagine that quite a number of people who fundamentally believe that it would be good to preserve the Union state voted to remain on the basis that they thought that was the best option for keeping the UK together. Equally, I think we know that quite a high proportion of the Leave voters were those who supported the Scottish National Party in the last election just earlier on this year, or so the surveys tell us. Now, there has nonetheless been quite little attention to the specific problems posed by Northern Ireland and Scotland, and I could talk about that at great length, but I won't do. They are very, very different scenarios, and I certainly wouldn't presume to be an expert on Northern Ireland, although the notion of Insta-experts has become very abundant and popular in the last few weeks. And I noticed that we are now almost a month away. It's been a long month. But in Northern Ireland, of course, the issue is not that of secession as such. It would be the issue of reunification of Ireland. And Northern Ireland is in a similar position in the sense that a lot of its trade occurs across the border within the island in the same way that happens in Scotland. But in this case, that occurs with a state that currently proposes to remain part of the European Union, namely Ireland, whereas with Scotland, if it wishes to remain within the European Union under some status, whether independent or still part of the UK, that would be with a part of the UK that has expressed an intention not to be a part of the European Union. So there are also very distinctive issues around the policing, cross-border policing, and the role of the European arrest warrant in Northern Ireland that I think merit specialist attention that I can't give them in literally 1 minute. Just to briefly talk about Scotland, though, what a lot of people have mentioned and just thrown it up in the air as if the pieces of paper are going to float down and make sense on their own is this notion of doing a reverse Greenland, which is in essence the notion that you could take a state that remains a member state of the European Union, but you could carve up the territorial scope of the EU treaties as regards that state. And this is, in essence, what happened with Greenland when Greenland ceased to be part of the EU. So for Greenland, read England and Wales. For the rest of Denmark, read Scotland, Northern Ireland, and perhaps Gibraltar. But that doesn't really tell us anything very complex because of the absence of any land borders and, of course, the very, very small number of people who live in Gibraltar. Others have argued that perhaps the experience of the island of Cyprus offers some interesting insights into how you manage issues around the fundamental freedoms across a land border between two parts of the island, where in relation to the northern half, the southern and the only internationally recognized state on the island does not have effective control over that territory. And experiences with Cyprus acceding to the European Union and with the operation of what is sometimes called the Green Line regulation may be instructive for how that could happen. Now, the only thing I'll say, and I'm sure my 5 minutes are up, is that these things are both uncharted territory, but they're also legally very, very complex. And again, coming back to the point about no trade negotiators, it's not clear to me that we have the expertise in the UK at present within government to negotiate all of those types of complex arrangements, whilst carrying on with the regular business of government in an effective way as at the same time. So I do worry very much that we have backed ourselves into a very dark place, and we're not at all sure how we're going to navigate our way out.
Joe, thank you very much. Richard.
In the old days, we knew where we were. Now it seems we are where we are. If I hear that phrase again, I think I'll go mad, but it's become a platitude. So where were we? We were with a post-war oligarchic consensus in which politics ran fairly smoothly. We had constitutional conventions. We had an ordered society, broadly. That all ended on June the 24th, when the genie was let out of the bottle in the referendum. I say it happened on June the 24th. It happened, of course, in the campaign leading up to the referendum outcome, which in my view was the constitutional equivalent of crimes against humanity. We sat through, sometimes slept through, a campaign of utter dishonesty, on both sides, but particularly on the Leave side. To make that point does not mean that I support Remain or Leave for the purposes of this analysis. But what it does mean is that we now face, as a result of this constitutional calamity, 3 questions arising from we are where we are. The first question is, should we be where we are? To which the answer is plainly no. It's a little like the Americans and the Brits wandering into Iraq with a photo guide, trying to plan for the future. Oliver Letwin was appointed as head of the Cabinet Office, wait for it, after the referendum result, and he was sacked about 2 weeks later. Are we where we are? Well, any Zen Buddhist will tell you we couldn't be anywhere else. But what next? Where do we go to next? And that question faces 2 possible analyses. The first is one of principle, and the second is one of prediction. Much of the discussion so far has been prediction. Will we be adopting a Swiss model or I don't know what model, it doesn't matter. But I think we have to, first of all, approach this as a question of principle. The question is, what principle? Now, if you search for a mandate from the referendum, do you go for the mandate of the United Kingdom voting collectively? Do you go for the mandate in each region, which was split completely, so that you leave Scotland with a reverse Greenland, you don't split Northern Ireland asunder, and somehow you keep the baby boom generation in line with the younger generation, in which case it's a little difficult to know what the mandate is? Or do you adopt some different mandate? Do you adopt the mandate that the majority voted for leave? What principle do you use to move forward? And it seems to me that the only principle is one that reconciles in hierarchic order the different dimensions of our political and constitutional and legal arrangements. In other words, do we put politics at the top? Do we put law at the top? Do we put the Constitution at the top? And what comes second and what comes third? In my opinion, the answer is ultimately self-evident. And it stems from something that Dominic said a few moments ago, which is that the Constitution, our constitutional arrangements, the legitimacy of our Constitution has to be kept together. It is too fragile not to. So to a room full of lawyers, this is quite a difficult argument to mount. All these legal challenges, I mean, they're very familiar. The lawyers get together, they crowdsource the funding, or they get together 1,000 businessmen. And what do? They put arguments forward as if a simple court case could decide what happens, to which the answer is plainly a legal argument about Schedule X3(2) of the European Communities Act has as much power as a water pistol against ISIS. If you're going to mount any legal argument, it has to embrace our constitutional realities. But in fact, no judge is ever going to decide, given the political momentum that this referendum has unleashed, that Parliament has got to have a vote or that Parliament has got to pass legislation. Forget the Bill of Rights. Forget Article 9. Just think of political reality. So it's a toss-up, really, between politics and the Constitution. And it seems to me that the constitutional argument for Parliament triggering Article 50 is unassailable, and I can expand on that if we have questions. But the political argument for implementing the result of this referendum as a collective vote of the United Kingdom to leave the European Union has to be followed. And if that is correct, it follows that the prerogative as a political guarantee that the referendum result will be given effect to has to be followed. Because Parliament might vote the other way. Parliament cannot guarantee what politics must deliver. So in my opinion, when you apply principle to this, the ultimate principle is not a legal principle. It is not a constitutional principle. It is a political principle that if we do not implement this referendum as it was advertised to the populace of the United Kingdom, there will indeed, as I think Dominic said, be civil war. Thank you.
I'm just going to move to the lectern so I can see people. Now, I did say at the outset that we would have questions and not statements, but I do wonder, in the light of what we've heard, whether there is anyone in the room who would like to put a sort of countervailing view that there isn't quite as much doom and gloom, there isn't quite as much of a sort of constitutional, legal, trade, quagmire and nightmare. Is there anyone who, a lawyer, who can put a countervailing view or argument, who wants to or dares to do so in light of the fact we have such a distinguished panel? If the answer to that is no, then we'll just take the first question. Okay? The answer to that is indeed no, so we will just take the first question. Please raise your hand. I don't know whether we have any roving... Do we have roving mics, or do we need them? The gentleman in the front row in the light-coloured suit.
Trevor Soames, Chairman of Sterling Brussels, one of nearly 1 million British citizens deprived of the ability to vote in the late referendum. My question to this very distinguished panel is this, I think, quite fundamental initial question. Is the provision of notice under Article 50 an irrevocable act? And the reason I ask that is that there's no provision in Article 50 for withdrawal, and the economic and political situation on the continent is in flux, as we all know. The rise of nativism and populism may well challenge the current status quo against which 52% of the population voted, as a result of which, in a couple of years' time, who knows what the situation will be in Europe. If we have provided our Article 50 notice, can we ever withdraw it? And secondly, if it cannot be withdrawn, should Parliament then not vote on it? Because any subsequent vote of Parliament will effectively be irrelevant, because we will be leaving the European Union, whether or not we get a suitable treaty and withdrawal agreement under Article 50. Article 50 therefore being determinative.
Okay, let's go to Dominic Grieve first on that.
I don't know the answer to your question. Looking at the plain text of Article 50, there is an ambiguity in it. On the face of it, I think the most obvious interpretation is that once you've given notice, it's irrevocable unless the other 27 member states agree that it should be revoked. You could argue that it might be capable of being revoked unilaterally if you don't get the terms, negotiated terms, because it's not 100% plain. But I think the political reality must be that if you embark upon a negotiating process having been given notice, which inevitably leads to your withdrawal or departure after 2 years, that in order to stop that, my best interpretation would be that you would have to agree amongst the parties that that should happen. And of course, with 27 member states, that could be quite problematical. But as I say, there are different interpretations, and the European Court of Justice would be the final arbiter, which wouldn't exactly be pleasant to the British public if we ended up having to determine that. So I'm sorry I can't give you a better answer.
Charlie Faulkner, I just wonder whether, there may be a situation where politics sort of overtakes, and, if there was an opportunity, for instance, to keep the club together, to keep the UK in, whether everyone would be happy just to scrap Article 50 and keep the show on the show on the road.
Well, I mean, I completely agree with Dominic's answer. I have no idea what the answer is. If you applied English canons of construction, it would be irrevocable. I know that it's not English canons of construction that would be applied. It would be the European Court of Justice that would determine it ultimately. My feeling is the question of whether it's irrevocable or not would completely depend upon the way that the 28 countries had acted. So if the position was that everybody, once the notice had been given, or when I say everybody, maybe the 27 other nations had busily prepared for our departure and had continued down that route, even though we purported to revoke it, my feeling is that the court would then say, I'm afraid it can't be revoked. If, on the other hand, we'd given it, and then, although there'd been no formal acceptance of the revocation, everybody had moved into a different position and had accepted in practice that it wasn't going to be enforced, then I think the European Court of Justice, in response to a piece of litigation saying, actually, you're out, would say, no, you're not, because it's absolutely plain that nobody paid much attention to it. So it would depend upon the realpolitik of what existed between the parties at the time, and the ECJ would, or what they're now called, would respond to that. So that's, I think, how it would be operated in practice, which means in practice that if we've served it and we try and revoke it, and the other 27 aren't having anything to do with the revocation, then the ECJ would reflect that in a subsequent decision that was reached.
Joe Shaw.
I'd rather tend to agree with that, and I think it emphasises a more general point that tends to be overlooked in the UK. That not only is there, as it were, EU law out there and European institutions, but each of the member states themselves has their domestic politics. Inevitably, each member state thinks that its domestic politics are only the only domestic politics, and certainly B, the most important domestic politics, even if they occasionally recognise that other states do. I think the point being that that the EU is in a state of flux. I mean, that was one of the wider, as it were, continental geopolitical arguments around the referendum that probably cut ice with about 0.00001% of the population of the UK, which was geopolitical stability arguments that would be affected by the UK's referendum vote. And but as I say, that doesn't have any political traction here. No, people are genuinely, I think, certainly in the EU academic law community, genuinely divided about the question as to whether or not revocation is possible. But if, as you're saying, in a sense, revocation then becomes overshadowed by the question of consensual extension, followed by probably a consensual amendment to the provision as well. If you're talking about a contentious position, then I think that in essence overshadows any issue about revocation, that renders those problems to be considerably bigger problems that the continent is facing, rather than just simply the question of the terms of trade of the United Kingdom, big as those are.
Okay, I don't necessarily want every panellist to answer every single question, but do either of you have a short point to make on that before we move on to the next
Yes,
question?
I do, because I disagree with the proposition that it is irrevocable. As a matter of law, I think it's revocable, because one of the provisions in Article 50 is that a state which has withdrawn must reapply under Article 49. So ex hypothesi, if you haven't withdrawn, unless you interpret Article 50 to mean you can withdraw before the end of the period, you're condemned to endless negotiations to pull out. You're really condemned to a new application under 49, which temporarily only happens when you have withdrawn. The counter-argument is you could drive a coach and horses through the whole process by continually withdrawing and then starting it again. But Professor Craig has a very good article on this, which is courts know how to treat abuse of process. So legally, I think the answer is fairly clear, but politically, politics will determine the answer, and I therefore agree with Dominic and Charlie Falconer.
Okay. Should we, Derek, you have a...
I'll just reluctantly come in. I agree what's just been said. If you ask me what the better view is, I think the better view is it's revocable. And I expressed that view to the House of Lords EU Select Committee a while ago. Michael Dugan, in evidence to a parliamentary committee, confided that similar advice had been given to the French government. There is support for that argument. The reasoning that's just been advanced, I advanced to the House of Lords Committee. There is also support for the argument in the Vienna Convention on the law of treaties, and I accept this is, as it were, flanking support. The EU court interprets EU law in a way that's not identical with international law. The position in international law would presumptively be, if there's a right to revoke, and it's wished to withdraw the revocation before it's been acted upon, then the revocation is revocable. And that seems to me to be a secondary argument in support of the first.
Okay. Thank you.
But at the end of the day, I accept, as it were, the Falconer thesis, that if it goes to litigation before the court, it might depend who's arguing this way, who's arguing that way.
Okay, thank you. The lady in the second row, I think, had her hand up first. Yeah.
Sweeling Harris from the Bingham Centre. I have a question following on from Professor Wyatt's argument in favour of enhanced parliamentary oversight, which I agree would be a very good idea. But of course, in the context of international negotiations, there are very good reasons for secrecy in terms of not putting all your cards on the table, not giving up, not showing your weak points to the other side, not allowing the other side to exact a significant cost because they know there's a point that you have to maintain so they can make you give on a bunch of other points. So I was just curious on, as to Professor Wyatt, your thoughts, but also the thoughts of the panel generally on how one would balance the tension between parliamentary accountability and that need for secrecy in international negotiations. Thank you.
Yes.
I agree there's a tension. The reason I referred at the outset to the position in the EU when the EU negotiates treaties is that the EU has not done a bad job. It has not done a completely good job, but it has not done a bad job of seeking to balance this tension. And in balancing the tension, I think we have to recognize that something very important has happened in our world. And that thing is that the public and elected representatives expect to have some say in a treaty-making process which will end up with legislation and will have as profound or more profound effects on life within a country or entity, as in the case of the EU, as any piece of legislation. I think sometimes the arguing in secret, playing the poker game, I think that is used very self-seekingly to justify the autonomy of negotiators. And if you ask, do I think the UK negotiating position will be enfeebled by what I've advocated, I would say emphatically not. I think it would be empowered, and it would contribute to creating that political consensus for the outcome of negotiations that would make arguments about a further referendum irrelevant.
Can I ask you, do you think that a hard-bitten trade negotiator would agree with you?
Well, I'd like to ask one, but I would say...
Do we have one in the room? We do. There's a gentleman at the back. Would you...
Hello.
Yeah.
David Allen Green, solicitor and legal commentator of the Financial Times. Just coming back to the...
Sorry, I thought you were a hard-bitten trade negotiator.
No.
Okay, sorry, I'll come to you in a moment in that case, if I want to get a few more perspectives on that last question before we do. Charles Falconer.
I very, very strongly agree with what Derek has just said, which is that you should distinguish between, on the one hand, the precise detail of these negotiations and the nature of the deal that we are seeking on the other. So if you took the three things that will be in play, single market, immigration, contribution to budget, there may be particular levels of budget amounts at the level of immigration, how the thing works, alternatively, the precise terms in which we get into the single market in relation to individual issues. And the precise detail may have to be kept precisely secret as to what our bottom line is. But those issues will very much be on the margins of the basic strategy that the country takes. And the idea that we could secretly negotiate with the European Union on those three issues without first having said what we're trying to get, what our aims are, whether it's Norway, Switzerland, Albania, Liechtenstein, is our model, is absolutely for the birds.
Yeah.
And also, I take two other points in relation to that. First of all, if and insofar as there's a conflict between openness and as it were, commercial secrecy, I think we have to go for openness. And secondly, the point that Derek made, which is incredibly important, if the fracture in the country, 58-42, is to be healed, there has to be this sense that the negotiations that were done with the support of the nation. The sorts of things that Derek was referring to, which were, for example, oversight committees in both houses of Parliament, consultation being done on an open basis right across the board, there being a sense that politicians, whom Dominic rightly said had been rejected in this process that led to the 24th of June, taking the nation with them means the openness and transparency, which Derek referred to, is not just some technical requirement. It goes to the heart of the place that we are at the moment politically.
Okay, Dominic, you've been making some notes.
Well, I simply thought that the chances of having a secret negotiation with the European Commission acting on behalf of 27 member states of disparate views and with a parliament in the background as a hotbed of gossip was an extraordinary notion. I mean, I know that some people in this country always think that the European Commission is a sinister conspiracy against the United Kingdom, and it has its faults, but I must say it's always come across to me as a bit like a dysfunctional senior common room. So I must say I am mystified at the idea that secrecy will be maintainable. And of course, that could be a very real problem, because I think that as the negotiations take place, there will be a constant series of pressures and cross-currents. And after all, at the end of the day, the negotiation will then have to be sold by the Commission to the 27 member states. And I think this is where the complexity of this process comes in. And I'd simply think that it's going to be a highly politicized, inevitably, process responsive to different strands of the political process in other European countries, which is why it's going to be so difficult to take forward. This isn't a trade agreement between the United Kingdom as some faraway country and the EU, which can be consulted on privately in the Council of Ministers when it's finally been reached by the Commission. This is going to be something which is going to dominate political discourse because it goes to the very heart of what the European Union is actually about, and indeed potentially the survival of the Union itself. So for all those reasons, I think this is going to be a roller coaster ride of a negotiation, and I wouldn't worry too much about secrecy. I think it's going to be talked about all over the shop.
Okay, all right. Let's move on to our next question. It was the gentleman at the back who I thought was a trade negotiator.
Not a trade negotiator.
No, I realise that now.
Just coming back to the topic of the seminar for Brexit and the UK Constitution. Not all problems have solutions, but one job of Constitution is to provide a constitutional solution to a constitutional problem. And we appear to have quite a difficult constitutional problem at the moment. Two of the things which killed off the British Bill of Rights were the Good Friday Agreement and Scottish devolution. Again, the Good Friday Agreement and Scottish devolution appear to be very high hurdles to pushing through Brexit. What happens if there is a clear objection from both Scotland and Northern Ireland to Brexit?
Okay.
They haven't got formal vetoes, but what happens? How do we solve that problem?
Okay. Richard, first of all.
Well, I mean, there are huge problems with both Scotland and Northern Ireland constitutionally. In relation to Scotland, and Joe will know more about this than I do, you've got the Sewell Convention, which basically means that in relation to EU matters that have been devolved to the Scottish Parliament, the convention, which is now in statute, or at least in embryonic statute, is that Westminster cannot legislate without the consent of the Scottish Parliament. The question is whether the Sewell Convention embraces foundational change in the constitutional relationship between Westminster and Scotland, or whether it only relates to the bric-a-brac of devolved matters. It seems to me that given that the Sewell Convention, which applies, of course, to all the devolved legislatures, is now in an Act of Parliament, or at least is in the Scotland Bill, as Clause 1, what it actually says is the government will not ordinarily depart from the Sewell Convention. Well, once you put something in a statute, although conventions have not hitherto been justiciable, it does seem to me is a real question of the courts getting involved. And as far as Northern Ireland is concerned, we know that devolution threatens trade borders between the two parts of the island of Ireland and also threatens the Good Friday Agreement because so many of the provisions are bound into the premise that both parts of Ireland are parts of the are members of the EU. So there are all those problems. You have to put them all in the mix, and I tend to agree with the suggestion that there are some problems that are incapable of solution. I don't at the moment see how you put all these things together and put Humpty Dumpty standing up in sober appearance.
Joe.
Yeah, so it's no longer a clause in a bill, of course, it's actually a section in an act, in the Scotland Act 2016, but that doesn't mean to say it's a legal veto. And in a sense, that epitomizes the type of problem that we have here, because the answer of simply keeping saying, you know, this is the Scotland and Northern Ireland answer to the problem called Brexit, in the same way that it's held back the problem called the British Bill of Rights and tried to keep us on, as it were, on a status quo situation, which itself, of course, is evolving. This isn't going to work for the sorts of reasons around popular direct democracy that have already been invoked across this table and the types of risks that there are with ignoring that. So in that sense, you need to look at a bigger type of constitutional settlement that doesn't simply say that, oh, you know, Theresa May and Nicola Sturgeon had a word and it's clearly a roadblock that we can't get around. Eventually, that's simply going to blow back up in our faces, and it keeps raising the question of the viability of the Union state. The issue in Northern Ireland, of course, is completely different, and we can see Northern Ireland. The British citizenship regime in Northern Ireland is effectively being completely hollowed out by the effects of the Irish rules on citizenship, allowing anybody born in the island of Ireland. And we also know, of course, that up to about 6 million people elsewhere in the UK are also entitled to Irish citizenship. And there are all sorts of ways in which Britain is being hollowed out by these processes. I don't have a sort of quick fix to how, you know, it's not going to be because Nicola Sturgeon and Theresa May have a quiet chat and say it's too big a roadblock, oh, we better forget it all, because it's not going to be like that. If a UK-wide situation arises with something approximating to the three paradigms that Charlie Falconer was alluding to, then this may be carried forward on a UK-wide basis. But that is simply going to result over time, maybe not immediately, but over time, to more hollowing out of the Union state. So if we want to preserve the Union state in the context of something like a new form of association with the European Union, then we are still going to have to fix those constitutional problems. They're not fixed in the UK.
Okay. I don't... let's have some contributions from the floor on this one. Two hands went up together. Different question. Okay, did anyone want to come back on any of that? Yeah, gentleman here.
Gavin Phillipson, I'm a professor of law at Durham University. I did want to come in briefly on Section 2 of the Scotland Act and the Sewell Convention, because certainly what I've read about it, my own view and that of Professor Mark Elliott at Cambridge, is that it is a bit of a constitutional oddity to have a convention in a statute, but it's nevertheless quite clear that it is still a convention. Section 2 is headed the Sewell Convention, and it's worded, it is recognised that. And the word that's used is that the UK government will not normally legislate. Now, it strikes me that that is simply too vague a provision, even if, apart from the heading of Sewell Convention, for a court to find justiciable, to the extent of striking down an Act of Parliament or declaring it not to be a valid Act of Parliament if you didn't have the consent of the Scottish Parliament, although it's possible it could be used as an interpretive clause in other contexts. So I'm not convinced that it's converted it from a convention into a legal provision. I don't think that was ever the intention.
But even if it has, let me just take your question on, perhaps Charlie Faulkner. Let me just add one thing for you to consider as well. Is the Sewell Convention argument a nice, in inverted commas, legal argument? Because ultimately the Westminster Parliament can do what it wants. And so if Scotland refuses to consent, well, that's unattractive as a constitutional sort of way of doing business, but Westminster will reflect the referendum vote and it will do what it wants.
Broadly, yes. I think that's right. And I think you're right to raise the point, and I think that the effect of Section 2 of the 2016 Act is intended to do no more than say this convention exists, make of it what you will. There is the higher principle that the Westminster Parliament retains sovereignty. I think what Joe was saying was incredibly significant. The question started off on the basis, look at all these terrible problems there would be about the precise terms upon which we might leave the European Union. What would we do about the Good Friday Agreement? What would we do about the Sewell Convention? What would we do about this, that, and the next thing? I don't think there would be any mechanistic difficulty, and it's a purely mechanistic issue, about passing an act of Parliament that would deal with all of those issues. But I think Joe's point is much more the real point, which is in the light of where we now find ourselves, with Northern Ireland, for example, facing a land border with Ireland, with Scotland not wanting to leave the European Union, and that has more than just the issues of what's its relationship with the European Union, but, for example, what happens in relation to Scottish fisheries, what happens in relation to Scottish agriculture. It shows that we are almost bound to need a new series of relationships within the United Kingdom. And those issues are ultimately, as Joe rightly says, not about how do you legislate to get out of the European Union. Let me tell you, we'll find a way to do that if that's the only issue. The issue is, what is the new relationship between Scotland and England in the light of this political difference between the two countries as to their relationship with the European Union? And I think it leads inevitably to a different sort of federation, using the word lightly, as between Scotland and England. And it almost certainly leads to much greater devolution between England and Scotland, so that there can be differential arrangements for the relationship between Scotland and the European Union, England and the European Union, Northern Ireland and the European Union, but hopefully without breaking up the United Kingdom.
Dominic, you want to say something?
Well, I was just going to say, I mean, so far as Section 2 is concerned, it's part of a very bad trend, often objected to, I suspect, by law officers over the years, of having declaratory legislation which is completely meaningless. And that is the problem, and it's not the first example of this sort of obfuscation which has been introduced into statute. And I agree with the analysis. I don't think it has legal force, although it can't completely be ruled out that somebody might seek to interpret it that way. As for what Charlie's saying, I agree, but of course, I don't want to add to the sense of chaos, but to add to the problems of renegotiating one's relationship with the EU, also a complete renegotiation at the same time of the internal relations within the United Kingdom, that is an extra burden which, whilst I happen to agree, I think is going to have to be addressed at some point in this saga if we are to survive as a United Kingdom. I have to say, politically, is not going to be a very inviting prospect.
No, I agree with that.
And for that reason, I can't really see it as being the first priority that the government is going to move towards. Like everything else with our constitutional settlement, it's tended to be forced on the United Kingdom rather than embarked on voluntarily. Which all adds to the uncertainties that we are facing at the moment. But the political realities are that although the SNP aspirationally wishes Scotland to be an independent nation, the practical consequences of doing it would be, I think, very serious for Scotland economically. Now, that said, man doesn't live by bread alone, and if the United Kingdom collectively does something very emotional like pulling out of the EU, why shouldn't the Scottish people do something even more emotional like breaking up the United Kingdom? So I've always seen that as being a potential problem, but against that I think there are some quite strong things that will keep us together. Although if people want to keep the United Kingdom together, they're going to have to do some hard work in order to bring that about.
Can I just
Yeah.
Dominic always says interesting things. He said a particularly interesting thing there, which is about his objection as a law officer to the sort of Section 2 type provision, which says, here's the Sewell Convention, make of it what you will. The first example of that was in the Constitutional Reform Act 2005, which says nothing in this act changes the role of the Lord Chancellor in relation to the rule of law, which I'm very glad to tell you, without breaking any confidences, the law officers objected to that at the time on the basis it was too vague. But it is that provision that now is in play in relation to the appointment of the recent Lord Chancellor, on the basis that if the Lord Chancellor has got to protect the rule of law as Lord Chancellors did before the 2005 Constitutional Reform Act, then when determining whether you're qualified by experience to do it, you've got to have a look at the role. And if there hadn't been that provision, you wouldn't have had the obligation.
Okay, all right. Let's not get sidetracked on your views. I think we all have read them in your Thunderer article the other day. Joe, you want to say something quickly if you would?
Literally oh, goodness me, I'm provoking people to leave. Literally two sentences on declaratory provisions, because I can see that they somehow seem rather offensive and problematic in our funny common law constitution that we have in the common law and part statute constitution that we have in the UK. But of course, they're extremely common in the EU treaties, and one of them was specifically one of the topics of the renegotiation, which was the phrase "an ever closer union between the peoples of Europe." I'll just leave it there.
All right, let's move on. I'm keen that we also get into some of the trouble down the road, if you like. We talked about, or I mentioned in the introduction, how we might want to go about the process of looking at the EU law that now is part of our own domestic law, and whether we want to excise that from our domestic law, and if so, how we do it. Anyone exercised by that, or, well, let's just take the next question that you are exercised by in that case. Do I see another hand going up? Yes, gentleman there.
Lord Falconer referred to the difficulties of negotiation, and he referred to the paradigm result. You very pointedly asked, which was an entirely reasonable question given this audience, where are the hard-bitten trade negotiators? Are there, in fact, any hard-bitten trade negotiation, which obviously is part of the infrastructure of Brexit, or are we going to rely on gifted amateurs with transferable skills?
Yes, actually, it's a really good question, isn't it? Let's go to Derek on this. What are we going to do for trade negotiators? Are we going to buy in? You know, are we going to just buy teams of trade negotiators in from abroad? Are we training our own people up as we speak? Is this like the beginning of the Second World War, where we've got sort of, a few Spitfires knocking around that might do the job, but we really need a whole air force?
Thanks, Clive, for that one.
It's been troubling me, that.
And it is a troublesome question, particularly because it's linked in this way to other agreements that it said the UK will have to renegotiate with the partners with whom the UK currently trades via agreements made by the EU. And it's sometimes said at the same time as the UK, this is relevant to the question that's put, it's said that at the same time as the UK is negotiating with the EU on a future trade agreement, it will also have to address and negotiate with the 50-odd partners to ensure either continuity or something new. Now, the first thing I'd say about that is I don't think it's actually true that we will have to deploy so many trade negotiators. I think that what we might do with the 50-odd partners we have via the EU, and this does sound a little like the amateur, gifted or not, I think what we propose is, to all those partners, we intend to carry on trading with you after the conclusion of the withdrawal agreement, the entry into force of the withdrawal agreement. The UK is out of the EU. The UK is hopefully into a new trade agreement with the EU. At that point, we propose simply to trade with you on the same basis as we have before that date. One could do that in most cases by a simple exchange of notes in the international law sense, and we could revisit at our leisure or the leisure of the trading partners the terms on which we traded. Why is that relevant to Clive's question? Because it means that in practice, we can focus on the big task, which is negotiating with the EU. Now, the honest truth is, I don't know, even if we're focusing our resources, where we shall get our resources from. We might entice UK negotiators back from Brussels.
Okay.
There are problems, obvious problems, potential problems with that, and others will learn on the job.
Yeah.
Or buy in negotiators from Canada, Anglophone countries probably knowing us. Not that there's anything wrong with Canada or Australia.
Okay, let me just ask our two panelists who've been in government, not at the DTI, but you know, people are perhaps petrified. It sounds a bit like, you know, you're a decent club tennis player and you're suddenly asked or told that you're going to have to play Federer and Becker every week, and that is pretty terrifying. You know, trade deals can take 10 years, they can take 20 years to conclude. They are immensely difficult and complex things to work your way through. Are we geared up, or can we get geared up to carry out a really good trade negotiation for the UK?
We're not geared up, but actually, before we start saying it's impossible, if the state puts enough resources into trying to recruit people, then although it will start not very well and mistakes may be made, I don't think it's impossible to get trade negotiating teams up and running, but we clearly start at a very considerable disadvantage. But it's not impossible, and I have no doubt that the work is already being done to try and bring it about, including potentially, I don't know, but I would think it's very likely recruiting people from other Commonwealth countries that may have got trade negotiating experience, or people back from Brussels. Governments are quite good at doing that sort of thing, but there's a difference between bringing it all together and actually making it work very efficiently.
Charlie.
I agree with what Dominic said. I mean, it does appear that we're rather short of the skill. My only experience of trade negotiations was when I was the Lord Chancellor. I would regularly go to India to try to negotiate rights of access for, probably you got involved in that as well, Dominic, for UK laws, and failed every time, which is a strong indication we weren't very good at trade negotiations. We will be disadvantaged because we've never done it before. My experience of the civil service and government is they are pretty good at knowing how to deal with these issues, but you never get round the problem that we haven't got the experience. So it will take time to get to a point where we're good at it, and what's more, we will end up in a situation where there'll be lots and lots of criticism as we go through it, particularly in the media, about how badly we are doing it, which may well undermine the sense of confidence in the deals that have been done. But my experience is it's probable that we're doing it better than people think, but disadvantaged because we've never done it before.
Okay. We have, the gentleman there had his hand up, yeah. Paul, sorry, the mic's just coming to you.
Sorry. Paul Hardy, EU Legal Advisor in the House of Lords. It's a question flowing from the last discussion. Quite a lot of EU trade agreements with third countries they're mixed agreements, so they've been ratified by the member states independently from the EU. So that means that the UK itself has ratified quite a lot of trade agreements with member states, which there is an argument to say would be recognised as treaties under international law. Is there any sense to the argument that the UK could rely on those EU trade treaties, which it has ratified itself, as a basis for a continuing trade relationship?
Derek, that's probably one for you, I think, to start, kick off.
Well, certainly just to start the ball rolling. The difficulty with simply relying upon that, Paul, is where the agreements are mixed agreements, the member states have only ratified them in respect of their own competence. Sometimes this competence is almost entirely theoretical and frankly is more political than even theoretical. And the recent example of the Commission saying, well, okay, let's call the Canada agreement a mixed agreement. Even though previously the Commission had not been able to find any national competence left over from the exercise of EU competence with respect to the agreement. So in short, I wouldn't leave it to that. And that's why I suggested a few moments ago that the UK cement with third country participants to trade deals the UK is party to via the EU, cement them with an exchange of notes to the effect that the UK wishes to continue and trade on the basis of those agreements as if the UK had remained a member of the EU. And if there's a favourable response, and of course I understand that in some countries there may be constitutional hiccups around that, but my hunch is most countries will simply want to go forward rather than enter into a negotiation that might well end up at the same point as it starts.
Okay, thank you. Can I just say, by the way, at this point, we're going to go on for about another 15 minutes, at the end of which time there will be drinks available, and we'd love you to join us for a drink. So just in case you're making a decision as to when you depart, then that, I see one person not tempted by the drink. Never mind. Okay, I'd like to just ask Richard, apropos of that last question. Richard, could you see the divorce settlement, as it were, becoming a mixed agreement? Could you see it fracturing, an individual EU state saying, well, look, we have a specific sort of financial concern here or interest, which means we want to do our things separately?
Well, this is a predictive question, which I predicted at the beginning would be take up half the evening. It seems to me that the problem with mixed agreements, as I understand it, is they have to be ratified not only by the institutions, but by every single member state. So clearly there is that danger. Whether it will happen, I have no idea.
Okay. Anyone else with it? Derek?
Just a rider, something that takes the sting out of mixity in practice. When a mixed agreement is concluded, it's very often concluded by a majority in the Council. The mixity means that all national governments and perhaps parliaments have to agree to them. But it's understood that the great majority, virtually all of the relevant competence, is EU competence. And so there is invariably a clause for provisional application vis-à-vis EU competence. And that's voted on generally by majority, so it goes in, no individual state can block it. And since the mixity is largely notional anyway, provisional application sees one through in a practical basis from the time of actual conclusion.
Okay. And as I read Article 50, it doesn't seem to be designed to accommodate or be designed for a mixed agreement. Do you agree with that, General? Richard?
Well, it certainly doesn't envisage, obviously envisage mixed agreements, but it doesn't exclude them. It's silent.
No. Okay. All right. Question. A few. Yes, gentleman there.
Omar Shah, Morgan Lewis. Quick question. Are we going to be allowed to negotiate the Brexit agreement, the withdrawal agreement, concurrently with the future trade agreement? Because Commissioner Malmström suggested that it would be consecutive. And the second question is, why existing?
Sure. I tell you what. Why don't we deal with the first one first, and then wait for them. So, okay. Is it actually going to be possible? I mean, trade agreements can take a lot longer than 2 years. Joe?
Strictly speaking, no. Clearly, it's it's out with the competence of the members of the UK as a member state to negotiate trade agreements either with third countries that are third countries to the EU at the present time, or indeed with the EU itself. It can't act simultaneously as a member and as a third country. Of course, we know that it may be possible to bring things to fruition, if you will, in an informal way, so that they can be resolved pretty much simultaneously. But strictly speaking, no. And coming back then, that reflects back onto the issue of how then do we deal with the question of transparency and openness, because it seems to me that there is in fact a conflict between, on the one hand, saying you can't do these things simultaneously because the UK is not a third country vis-a-vis the EU until the date of when it withdraws. But on the other hand, we want to do these things. We want to do these things openly. We can't do them simultaneously and openly. So, I'm not sure.
Okay. Anyone else? I mean, obviously, it would be desirable, wouldn't it, to do everything in the one agreement, in the 1 2-year period?
It would clearly be desirable. There's a very, very good discussion in the Treasury Select Committee's inquiry into this on the 5th of July, where this whole question is debated. And the consensus appeared to be that as a matter of strict law, you cannot do them consecutively. Sorry, you cannot do them at the same time in parallel.
Right. Okay. All right. Sorry, Derek, you just want to make one comment.
I agree with that technically up to a point, and the point is this. Article 50 refers to the withdrawal agreement. Article 50 only provides a procedure for a withdrawal agreement. Obviously, it's an exceptional procedure because normally the EU cannot conclude an agreement with one of its own members. But the Article 50 refers to the withdrawal agreement, taking into account the framework of the future relations agreement. Now, that presupposes that it is lawful to have sufficient negotiations as regards the future relations agreement in order for it to inform the express procedure for the withdrawal agreement. How would that work? Very, very briefly, I set it out in more detail in my evidence to the House of Lords EU Select Committee. One would have a shadow negotiation on the future trade agreement in order to inform the withdrawal agreement, and one would use the same procedure, that is, with negotiating mandate to the Commission from the Council and liaison with the Parliament, as one would use after the event, and one can synchronize the treaties coming into effect by a conclusion in accordance with the formal procedure for concluding an agreement, which might be either majority in the Council or unanimity if it's an association agreement. Forgive me scampering through that, but it is feasible, and I think it's likely that that will be the course. And some heads of government have already begun to speak about negotiating in tandem.
It must be the case, as a matter of political common sense, that if there is a desire to enable a reasonably smooth transition, that is the only way in which it can be carried out. And so I think the argument for it is overwhelming. The only circumstance it wouldn't happen is if our relations with our EU partners are at such a bad ebb that they want to prevent it from happening. And I find it very difficult to see that it would be in their interest to do that.
Okay. I think you had a fair amount of time on that, if it's okay, because I have seen a couple of other hands go up. There was a gentleman just behind who's got his hand. Yeah.
Good evening, Stephen Hockman. I think I should begin this rather pessimistic comment by saying that I was a passionate Remainer, I dare say, like most of the people in this room. But I do wonder whether we aren't in danger of approaching this in rather too complicated a way. It seems to me that Article 50 and the notice of withdrawal under Article 50 does represent a watershed. Until that happens, one can envisage a situation in which a country which wants to withdraw says to the other countries, unless you agree to X, Y, and Z, unless you agree to special arrangements for Scotland, unless you agree to our terms of trade, then we will withdraw. But in a sense, we've already had that discussion. David Cameron spent months trying to negotiate on that basis, and he got to where he got to and the country has now decided that it wants to withdraw. So once the Article 50 notice is served, the puzzlement that I have, and it may just be, I mean, the experts may be able to answer this, but what leverage do we really have? Are we really going to say to the other countries in the European Union, if you don't agree to what we want, we won't withdraw? Because that's the logic of the situation.
Yeah. Okay.
And
all right. Let's just address that point. I think a lot of people wondering, you know, once we trigger, have we lost all of our leverage? I think is implicit in that. But Dominic.
Well, we don't lose all our leverage, because the argument must be that it is in the interests of our European partners to agree a deal which is not a deal, a withdrawal with no deal, because it is in their interest to do it because of the sake of their own exports to us and their trade with us. But I agree with you, apart from that, that's the only leverage which arguably we have. It's one of common interest. Until we've invoked Article 50, then there is, I suppose, the extra leverage that at the moment there is uncertainty, and nobody likes the uncertainty because it creates even more tensions and problems within other EU states. So they may feel that, in a sense, they're being a little held to ransom by the United Kingdom, just sort of saying, we're going, but we're not quite telling you when. But I think in both cases, it's ultimately, well, certainly the first case, is a matter of political goodwill. Is it in the interest of the other EU states to have a deal with the United Kingdom if you're leaving? And you can see the tensions already present. Angela Merkel seems to be giving the impression to the Prime Minister that she thinks a sensible deal is in everybody's interest. Monsieur Hollande is apparently, from what I read in this evening's Evening Standard, giving a rather different impression, and doubtless playing to a domestic audience which has different priorities. All this highlights how very difficult this is all going to be. But I don't think there is absolutely no leverage, because as we are so mutually interdependent on this continent, ultimately, to have chaotic outcomes is in nobody's interest.
Okay. I agree with that, but it boils down to the leverage that we've got in the negotiations, because we're definitely going, is whatever particular things particular countries want. So, for example, Spain will want something on Gibraltar. Germany will want something on financial institutions. And so the only leverage we've got is those individual deals. And obviously, and it's implicit in what Stephen was saying in his question, the leverage gets worse the moment we serve the Article 50 notice, as everybody knows, because at the end of the 2 years, we've got nothing to say except beg for some interim arrangement if the negotiations aren't complete after 2 years, and they almost certainly won't be complete after 2 years unless, before we serve the Article 50 notice, the broad parameters of the deal are accepted across the European Union.
Rishi, can I ask a question, actually? It comes out of that. If, you know, it becomes the view in government that actually we shouldn't trigger, and we delay and we delay and we delay triggering Article 50. Does there come a point at which there is some kind of deemed triggering, or the other 27 say, we deem you have, yeah, come on, we've been waiting long enough?
No, I think not, which is the, going back to Stephen's point, that's the leverage we do have. I mean, the point that I think is, however, important is that it would be very damaging not to trigger it for an unreasonable period of time, because it would very much affect our constitutional arrangements. The mandate of the, as I think, of the referendum was to trigger Article 50. And therefore, just leaving it is not so much a breach of EU law, but a breach of our constitutional legitimacy.
I'm not sure, but I think the question of how you do it is a matter for the government of the day. They may need a mandate in relation to it. But I don't think you could say, if the government of the day judged that the best way to get out was to wait for 2 years, that we breached the mandate from the referendum.
Possibly not, but I do think that this is a problem with this referendum and the Scottish referendum, which of course led to the vow at the very last minute, that if you ask a binary question and don't ask any other questions, you are left with a constitutional mandate which is not nuanced at all and which can only lead to one outcome. If we had gone in Scotland for Devo Max, which was put to Cameron, I think we'd have had a much more rational result to the Scottish referendum, and ditto with this one. But I mean, the difficulty of asking that one question either or, is that we do now have a mandate.
The government have an instruction, in effect, to leave the European Union. They've got to decide how they do it. If they stop doing that, then they would be, as it were, in breach politically of what the referendum said. But I don't think that would put any necessary time limit on it, as long as they were doing it. And I definitely disagree strongly with the proposition that what the referendum decreed was they had to serve an Article 50 notice. So, for example, if an agreement was reached without an Article 50 notice, that would be fine.
But let me just put this question. If, at the end of the day, a negotiation is reached, and I think there's a growing body of opinion that would like to see a second referendum, and the people at the second referendum reject the terms on a binary question, what happens then? Do we go on having referendum?
I think that's a different question.
All right. It is a different question. Yeah. And I know Jo wanted to answer the preceding question, so let's let her do that.
I think the idea that Charlie Falconer's putting that we could reach an agreement outside Article 50 is an interesting one and doubtless being pursued in appropriate places. But it does raise, it does also raise the question of with Article 50 potentially running into some quite serious domestic politics obstacles in other member states, notably the elections in France and in Germany. We talked about what does Germany want, what does Spain want, well, what does France want? And there we have the possibility that the very high probability that Marine Le Pen will be amongst the candidates in the runoff. And there's a binary question to which we hope there will only be one answer. Because I think the other way will be very highly problematic and will be the end of the European Union as we know it. Now, the other question is, what does Scotland want? Because in return for this, if the UK as a whole has got itself into a binary situation where the only way that it can get out of that is by buying favours in different places, in Spain, in Germany, in France, and so on, there's also the same issue arises in relation to Scotland. What is going to be formulated as what Scotland wants. It's not clear to me that Nicola Sturgeon wants independence at this particular time. The economic arguments in favour of independence have, as many people have pointed out, become much weaker. But I would think that regardless of the fact that the people are saying here also, let's not engage in extended constitutional ruminations at the same time as trying to fix this fundamental problem of foreign policy. Nonetheless, that's clearly the direction in which the UK is likely to go, towards a more federal future, and that may be the basis on which Scotland can be bought off, if you will, provided, of course, that we still have some assurances in relation to certain aspects that are very important to Scotland, around immigration policy, for example. A decentralised immigration policy may be the sorts of thing that Scotland needs to include in its shopping list.
Okay, Jo, I think we now have come to the end. Sadly, we've come to the end of our allotted time. It's been a terrific panel discussion. It may not leave you skipping away from the hall with a song in your heart, but we didn't advertise or guarantee that at the outset. I think it will leave you with a much deeper understanding of the issues, and for that, please show your appreciation to our very distinguished panel.